What's good? What's good? What's up, world? What's up, world? It's your boy Neutron the Don. What's good? Your boy, your filming podcast. What's good? We back with another one. Just a little recap for the end of the new year coming up, man. Shout out to Young Thug, boy. We're glad to see that boy home. You know what I'm saying? I was just watching, like, well, it's a lot, boy. Like, the judge got kicked off the case. The judge did some French word called ex parte. He got kicked out of the case doing something illegal with the witness. He in the judge's chamber was like, well, there's a ratting on top of ratting. Like, what? The judge's chamber, like, Lord. I'm gonna let y'all watch this a little bit right here. I'm gonna let y'all see a little bit of this right here. Then we're gonna talk about it. Let's go.
Right.
I don't see how you rewind this case to June the 12th.
I look at what's next for the months-long RICO trial and talk with one of the lawyers caught up in the controversy. Plus, what does Young Thug's lawyer have to say about a new judge coming on board?
I definitely anticipate motions for mistrial, motions being filed for a mistrial.
Welcome to Crime Fix. I'm Anjanette Levy. Judge Earl Glanville is no longer presiding over the RICO trial of Jeffrey Williams, who's better known as rapper Young Thug. I'm going to go through the order for Glanville's recusal, but first, a quick recap on how we got to this point. It became clear that Glanville's days of overseeing the case might be numbered on June 10th when he held Williams's lawyer, Brian Steele, in contempt after Steele questioned why Glanville didn't tell him about an ex parte meeting in chambers with the state's star witness, Kenneth Little Woody Copeland, and prosecutors.
Mr. Steele, I am going to still hold you in summary criminal contempt.
The Fulton County DA's office maintained there was nothing improper about this meeting.
We certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of.
After Steele was held in contempt, he appealed and received a supersedeas bond so he wouldn't have to go to jail. That appeal is still pending. The trial continued, but you could tell things appeared to be pretty strained. Steele and attorney Doug Weinstein, who represents defendant Diamante Yak Gotti Kendrick, filed motions asking Glanville to recuse himself. Glanville eventually asked another judge to weigh in on whether or not he should be recused.
Upon further review, this court will in fact enter an order sending Mr. Adams and Steele's, Mr. Weinstein, and Mr. Banks' motion to recuse to another judge.
Eve Online on Mac immerses you in a universe with thousands.
My bad.
Judge Rachel Krause got the case and made her decision rather quickly. In a 10-page order, Judge Krause cited case law to support her decision that Judge Glanville should be recused. Judges shall disqualify themselves in any proceeding in which their impartiality might be reasonably questioned. Judge Krause continued, a judge has no interest in sitting on a particular case at most. His interest lies in protecting his own reputation. His efforts at defending himself against a motion to recuse will inevitably create an appearance of partiality. One reason.
Now, see this right here. The judge, her sheriff, was sleeping with one of the witnesses or something like this. This is crazy. Like this in Fulton County is crazy down there in Georgia. So the judge had to recuse herself because one of the sheriff was sleeping with one of the witnesses. Like, this is crazy down here in Georgia, bro. Like, I ain't never seen the law. The law is crazy down there in Georgia. You get 17 years probation. Never seen nothing like it, bro. Like, for real. I thought Charlotte was, man, listen. Charlotte, all right, but they fucked up. But this is, man, you got people coming through walls and shit trying to kill you down there in Fulton County. They call it Little Haiti. Come on, let's listen to some more of this. The judge didn't even want to take the case because she knew the case. Didn't nobody want to take this case. The case was some BS the whole time. They were just trying to get Young Thug, the big fish. That's what they call it. But let's listen to some more.
Is that if he defends himself, he becomes an adversary of the movement for recusal. This adversarial posture may create an antipathy, which persists after the motion to recuse is denied. Judge Krause wrote that there were 3 criteria for determining whether a judge should recuse himself or herself. In transferring the case to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied, i.e., that recusal might be authorized if the facts alleged in the motion were assumed true. Once the motions to recuse were filed, Judge Glanville couldn't argue against them. He's essentially prohibited from doing so. Judge Krause wrote, "A judge cannot become actively involved in presenting evidence or argument against a motion seeking his recusal without that defense itself becoming a basis for recusal." So what did Judge Krause think about the ex parte meeting? She appeared to choose her words very carefully. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken.
Now listen to this. You said actually say she chose her words carefully because she knew it was illegal. The judge meeting with the defendant is supposed to be testifying against somebody, and you ain't got the defense there. Come on, what this is crazy. You just locked them up for pleading the fifth. Now y'all want to give them an ex parte and then say, oh, the defense don't supposed to be there. You seen the black DA get up there and lie. So what? Come on, let's listen.
Taken place in open court. Nothing about the fact of the meeting or the substance discussed was inherently improper. However, in his order denying defendant Kendrick's motion and in the process of making his record on July 1st, 2024, Judge Glanville added facts, provided context, questioned the veracity of the allegations, and otherwise explained his decisions and actions and argued why those actions were proper. So Judge Krause basically said in that last part that Judge Glanville may have crossed the line when he tried to explain himself. In granting the motion to recuse, Krause wrote, "This court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville from further handling of this case."
Now, hold on, listen to that. She basically saying what we all thinking. If you think he can handle it fairly, so why are we even having this motion right here? Why was he doing that? He knew he was a judge. You know you don't supposed to be doing that deep. And then he told you, he tried to lock the lawyer up. The lawyer say, "Let I go to jail with my client." You know what I'm saying? Shout out Brian Steele. It's crazy.
Kayla Bumpus represented Kenneth Little Woody Copeland during that ex parte meeting in Judge Glanville's chambers. She was one of the people ordered to show cause as to why she shouldn't be held in contempt for disclosing the information. I spoke to her about Judge Krause's decision.
I think it was the right thing to do. I think it's a step in the right direction for these guys to begin to get a fair trial.
Judge Krause ruled that the show cause order related to Kayla Bumpus was moot. Glanville had mentioned that he saw Bumpus on surveillance video talking to defense attorneys. This is her response to that.
Judge Glanville, I can't remember if we talked after this, but I think we did. I mean, he put on the record that I'm on camera talking to Attorney Steele. So there's no question that me and Attorney Steele and other members of the defense team, Attorney Weinstein, there's no question that we had a conversation, and I never denied having a conversation with them. So yes, of course I talked to them, and I did tell them things that happened in that meeting. But if I had a chance to do it all over, I'd do it the same way.
But back to the RICO trial and the motion to recuse being granted.
Yeah, that's the lawyer that was in there with the witness. That's Kayla Bumpus. She was in there with Lil Woody, the dude who's supposed to testify against Jack and Shannon. The judge in there with the DA, and they trying to say that, look, the defense. So I don't think she was the first person to tell the defense. The defense already knew. See, like, what happened in there? Why we ain't know about this meeting? You were with a lawyer. So so the judge, like, we seen you on camera, blah, blah, blah. He got mad because they got caught. Like, come on, who gonna hold them accountable down there in Georgia, bro? They trying to try Trump already. I think, well, listen, Trump gonna come down there in Georgia and make some change in legislation down there. You hear me?
Judge Shakira Ingram has been randomly selected to preside over the trial.
I definitely anticipate motions for mistrial, motions being filed for a mistrial. I can't see anything other than that happening next.
How does a judge come in and take over in the middle of something like this that has gone on now for so long?
And for me, it's not.
Check this out. I'm going to show you how I afforded this card.
My bad, my bad.
Judge, it's more about the jury. I mean, how do they know what parts to trust, what
Hold
parts
on, look,
not
cause
to trust? There's no way that they're going to not know that Judge Glanville was recused. They just can't show up one day and then there's a new judge. I mean, they have been sitting in this courtroom watching a lot of these motions and hearing a lot of this stuff. And, you know, it's just the jury is like the big thing here. And we know it took 10 months to get that jury. So it's even
yeah.
if they retry it, I mean, then how long do we have?
When it took 10 months to even get the jury, they had over 2,000 jurors. You know what I mean? I don't know if y'all down here in Charlotte. I mean, where y'all at? I mean, wherever you watch from, if y'all even seen this. But this been like a kangaroo court down there. You know what I mean? This is crazy, man. Shout out Thug, man. Free Spider. First Spider home, man. Man, wish you would have humped Spider, man. You would have beat that. Them boys got found not guilty. I know that hurt you. I know. But if you'd have stayed in that case, man, they probably gonna keep dragging it out. Y'all probably still would have won. But it's just going, I mean, it was better that you get out the way before they try to keep doing something, because Yak's still in there. But, you know, that's another story. I understand all that.
Have to wait for another jury. So I'm excited to see what motions are filed. I'm excited to see what happens next. I hope that if they do continue to move forward, that at least these guys are given bonds, the ones that, you know, qualify for bonds. Of course, we have rules that come with bonds, but I think that some of them definitely should have been given a bond from the beginning. And if they do choose to continue to move forward, I hope that Judge Ingram at least considers to give these guys a bond.
Attorney Doug Weinstein represents defendant Diamante Yak Gotti Kendrick and had filed a motion seeking Judge Glanville's recusal.
This is a huge win. This is a huge win because, look, again, I'm going to say what I keep saying, and I keep saying it because it's the truth. I do respect Chief Judge Glanville. He has a great reputation. He's done tremendous service to this community and through his military service. So I have a lot of respect for Judge Glanville. But at some point, I think any dispassionate observer of this trial on your network or anywhere else can see that, unfortunately, I think the judge has let bias creep in. And so I firmly believe that if this case were to proceed with an unbiased judge, we would get justice, we would get the outcome that our clients and Mr. Kendrick, and again, I'm just speaking for me, but that Mr. Kendrick deserves. So this is a huge win.
Unfortunately, the world is not always a safe place and accidents can happen. That's why I want to.
Yeah, man, that's crazy, bro. That shit is crazy. Watch this, man. This is crazy, bro. I was just like, man, I'm glad that man made it up out of that. That was crazy, man. Let me see. Law and crime. Then they leaking out that, man. It's crazy, bro. They leaking out footage and shit. Uh, they leaking out the man footage of jail calls and shit, bro. See, they got 8 hours and shit. They got hours and hours. Let me show y'all this right here. These type of witnesses they be putting up right here. Now watch how the judge.
Did you know you don't need a computer science degree to work for?
I don't know what that is.
Marco, you can go ahead and step outside for us. Thank you.
Shit crazy, man. The dude, you know what I'm saying?
Your Honor, so
Statement.
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting, this is who it belongs to. So that was my objection. I believe the objection was well-founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for a mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't see.
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with, where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked, Joe. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number with the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor.
I literally
And
asked
I
that.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking
I
for one.
can't figure out what it is. If it's disingenuous, if it is that, I mean, I don't want to malign the prosecutor standing in front of me right now. So I'm not going to say the possible things that it could.
She want to say she either you dumb or you just a criminal. You've been lying to the court. You say you ain't offering it for the truth, but clearly you offering it for the truth. You don't know who the fuck phone number it is, but you somebody say, no, we're just trying to see how did he get to this assumption. So if you say then you supposed to took all that off the right side of the paper. You still trying to get up there and ask that man this. Like, that's crazy. This DA right here, this lady is crazy. I'm glad she's not in Charlotte. Let's continue.
Could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful. But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody.
See, I'm talking about that shit crazy, bro. This is shit that thug went, man.
Hey, it's Jay Shetty. Are you looking?
Georgia. That is crazy, bro. Let's look at this right here. She about to get on there again.
Actually, you would like to have admitted and published?
Yes.
I mean, can you do that from now on without me having to beg you to do that?
Your Honor, the court does not have to beg me for anything.
Okay, I mean, let's just have it be sort of a standard, which I thought would have been clear anyway, but is apparently not, that you make it clear to everybody what parts of what exhibits you want in evidence so that we can then, if there are evidentiary challenges to them, be able to sensibly discuss those. Is that something you can do for the court and for the opposing counsel in this case?
Absolutely.
Okay. So can you right now let us know so that while we're having our half hour, we can take a look at all of that?
Sure can, Your Honor.
All right. Thank you.
Look, you see how she got up? You see how smug she was with that? She like, come on, man. Like when you scold a child, they get up all mad. Yeah, sure. I'm trying to be smart, but that's the overall teacher. You can't be smart with the teacher. DA.
And the objections, as stated already, generally were hearsay, confrontation clause, and authentication. There's not going to be a confrontation clause issue. People's Twitter posts are not testimonial. But with regard to authentication and hearsay, I mean, I don't know if
He can set the foundation and he can
authenticate these.
I believe that.
Okay, maybe. All right. And then there may, okay, so let us know. How are you gonna let us know that? Because can you email to everybody the portions, or how are we gonna?
I can give you the specific page numbers.
Okay, and everybody else has a copy?
Everybody has this. Yes. When you say everybody else has a copy, I'm not sure what the court means.
If you give page numbers, they have a copy so that they'll be able to easily find and look at what that is?
If they scroll, if they look at the.
Do you remember? They have a link. Do you remember which link it is?
Yeah.
Can you let us know that, or at least them know that?
I'll just yes, I can.
Resending it would be great, and then pinpointing.
And perhaps telling us where it is in the discovery.
No, she's going to resend it, which would be easier. Okay, so you will do that and be specific about what.
Look at her, bro. Look at her. She lying. You see how she flipping that paper back like she. What are you talking about? Like she don't know what they talking about. You hiding all the evidence. You dragging along evidence day after day.
Part you want in.
Oh man.
All right, Mr. Sharp, you had asked in the midst kind of all of the objections that the court give an instruction about the blank box. Is that something that you still want me to do, that the box was blank at the court's instruction because we didn't at that point have anything establishing the date, or?
Yes, I would very much appreciate the court giving that instruction.
And that was states 44, I mean, not states, I'm sorry, Mr. Stillwell 44.
I believe that's correct.
Okay.
I can check. I'll approach and look at the evidence and confirm.
Okay, and so I'll just tell them that it was at the court's direction that the box was blank because it hadn't at the time been established what the box meant.
Your Honor.
Will that work? Yes, no?
Yes, that would be
Okay.
great. Thank you.
Yes, ma'am.
Your Honor, that requirement of the court was not on the defendants. They objected to that box being shown. The state had no objection. So in as much as the objection leveled by Mr. Stillwell is what the court based that on, and the state did not have an objection, and the state actually explained what it was, and Mr. Stillwell could have very well put that date in the box.
No, Mr. Stillwell could not have at that point. There was an objection to it. I will give that instruction, and I'm also going to instruct that the state may not in any way attempt to argue that Mr. Stillwell was trying to hide anything by having that box on there blank. Understand? And I'm not saying you would, but just want to make that clear. Understand?
I think, yes, Your Honor.
Okay. All right, I would also, let's see. So,
Like, this is the deputy DA right there in the green, Miss Love. Ain't nothing love about that, bro. Listen, she played dirty. You hear me?
so we're going to deal with the Twitter feed issues and the reconsideration of Zachary's things. Anything else?
The additional crime scene photos
Your Honor,
from Mr. Atkins.
I don't know if we'll get to that or not. When would that be coming in?
Not it.
Your Honor, those probably won't even come in until the next week or the week after
Well, they
next,
may not be
depending.
coming in at all.
Well, if they are to come in, it would be in about 2 weeks from now.
Okay, and it was so like, you said, or somebody said that the CADs with regard to those had already come in. Can y'all be a little more specific about what those are gonna be crime scene photos of? And why, like what crime scenes and why? I know Miss Love, you said, oh, you put them back because of witnesses that you had to add back in. Can you give me a little more specificity about the?
So at the begin, you want to know the actual
Crime scenes.
Okay.
And then
I hired an AI personal assistant to do literally everything for me. I was lazy today. So in the morning, I had highlighted.
did you have to add those witnesses back in?
Well, the why was when counsel for.
Was it because you were establishing who lived at places and they were gonna object unless you brought the person in?
That was half of it. The other
Okay.
half was that they objected to any of the
Chain of custody, I remember.
right. So,
Anything
right.
beyond that?
Yes, so I'm pulling up the actual incident number.
I mean, if you want to just give me an address, like the so-and-so crime
But-
scene.
But these photos, Your Honor, were not produced in discovery.
I understand.
Okay,
I'm
thank
gonna get to that. I'm just trying to get a little bit of basis for what we're even talking about.
So it was 717 Cedar Avenue. I don't have the date on that in front of me.
That ain't funny.
Well, one was 2014, one was 2015, one was 2019, as I understand it, which
Stop
was
putting
that.
out. That's Miss Love. That ain't funny. That's Funny, the head DA. That's the deputy DA. That's Miss Love. Wow.
That was 2014.
Okay.
And that was based on an objection about the kniving hits. And then there was the 807 Prior and 193 Hendricks shooting, which I think was that was in 2015. That was one of the retaliatory shootings. And then there was the 2019 one regarding Milton Howard in Rayshawn Lucci Bennett's vehicle.
Where?
On the road. It was, the specific address was.
This is.
You see how she you see how she whispering out like she like where oh Sylvia, man, come on, man, quit playing them games. Watch the judge get on.
Something there was just testimony about last week. Yes, no?
Oh, yes, I'm sorry. I thought you- That was rhetorical.
Make sure y'all like, subscribe, and share, baby. Make sure y'all like. Wherever you watching it, man. Hit them heart button, hit them likes up, man. Comments too. My daughter right here fucking with me. Let's sit down there. What, baby?
Okay, well, in any event, you say you added witnesses back because of needing to establish who lived where and the chain of custody, I guess, for like bullets and shells and things like that. But if the photos themselves were never provided, which is what Mr. Atkins represented in his email, then why should they come in now?
Your Honor,
My bad.
Capacitor course check.
My bad.
so as it relates to the scene, we believe that it's relevant information that
Why she start stuttering and fumbling and bumbling and jumbling with this word salad? Terrible word salad. You know what I mean? For a lawyer, this terrible word salad right here. Just like a rapper when they be mumbling and mumbling. This is what you call word salad. Watch this.
does not unfairly prejudice anyone, as the incidents themselves are very much a part of the discovery that we've provided.
But the crime scene photos aren't, right?
Your Honor, I believe I believe that they have not, but I will make certain that they've not. I believe that
Well,
they have
Mr.
not been.
Atkins represented that they haven't.
And I have
so-
no reason not to
Okay,
believe.
so you check on that in our 30 minutes or so that we're going to have, and you can let me know. All right, let's be back here at 1:20.
Your Honor,
Yes.
I know that Mr. Sprinkle had no more questions on direct by the state, so I will put in writing. He mentioned some phone calls, jail calls. The state mentioned with him, but they didn't put them in. I have some objections to portions of those jail calls, and I'll put it in writing for everybody. But I just wanted to make the court aware, just in case the state wants to, on redirect, somehow get into those jail calls.
Are you going to get into the substance of jail calls with Mr. Sprinkle?
Not today, no.
Okay. Ever with Mr. Sprinkle?
At some point, yes, after we get other, yes.
Okay, then, yep, go ahead and put those objections in writing.
I'll do it.
And one more thing, Mr. Steele, you sent over an email sort of setting forth an objection or a continuing objection, I guess, that you have to the testimony of Mr. Sprinkle about his investigation, and he based it on Davis versus State, 307 Georgia, 746 from 2020, and also Adkins v. State, 301 Georgia, 153 from 2017, and the law that's set forth in those about conduct of an investigation, an officer not normally, only in rare instances being relevant, but that it is relevant after, or its case law appears to acknowledge that it can be relevant after a defense has raised questions about an investigation. And yet you're saying at the same time that your co-counsel is asking Mr. Sprinkle questions about his investigation, that you don't believe that it is relevant here because the defense hasn't challenged Mr. Sprinkle specifically. And that is, I appreciate that nuance, but my original ruling on that stands. So I'm going to overrule your objection. You may have a continuing objection to that. All right. See y'all back at 1:20.
Right, this right here, man. This.
Hey, sorry for interrupting. Isn't that annoying?
Yeah, you definitely.
I told you there was a way to get rid of ads like this.
Quiet, quiet.
No, I don't want to see that. Hell no. But oh my God. What you doing? You okay? Sit down. You can sit up right on there. I want to climb on shit. Quit climbing on shit. You tripping.
Y'all want me to volunteer or take a subpoena? What I'm gonna volunteer and take a subpoena for?
Oh, Lord.
Did you
Listen
tell
to this nigga.
your father to tell us you weren't gonna come?
My father, he grown man, he tell you what he want to tell you. I ain't telling that.
Were you with him when he said you weren't gonna come?
No,
Do you know whether he, offered to call anybody?
you want to get my dad up here?
I wanna talk to you.
Okay, I know you want to get him up there.
Why?
You know why.
Why?
You know why.
Tell the jury why.
You know why.
So you're not gonna tell the jury. Was your father with you when you talked to Gaither and Dennis in August 2015?
No,
Did you live with your father in August 2015?
no,
Who did you live with in August 2015?
myself.
Did you live with SG at any time?
Yes.
In August 2015.
Yes,
Where did you all live?
I don't remember.
You said that you were closest with Moonton, or you were coolest with Moonton. All right. Were you coolest with Moonton in April 2015?
April. Yes,
And were you cooler with Moonton than you were, say, Shannon?
yes,
Now, in April 2015, were you also cooler with Demetrius?
yes,
April 28th, 2015. Do you remember being with those people?
yes.
Where?
That when we caught our case, we was in the car together.
What kind of car?
I don't remember what kind of car.
What did you have in the car?
A gun,
How many?
2, 3, 1 on.
And what time did you all get in the car together? Daytime or nighttime?
Night.
Was it after?
This is why you never get in there. You know what I mean? Get in there, start working with him. Listen, man. The man got sickle cell. They locked him up at the hospital. You know what I'm saying? He was like maybe 14, 15 there when this first, it was 10 years ago. So he was, I think he about like, I don't know, but he was in there telling. But, you know, allegedly, he lying, making up shit. Him and Woody, and it's just terrible. Ratting, period.
After 10 o'clock at night?
Yes,
Had either you or either one of the people you were in the car with been to Club Crucial early?
I think they was.
So how did you end up in the car with them?
Came and got me.
Did you ask them to come and get you?
Yes.
Why?
No offense, but if you're paying more than $30 per month on car insurance, you're getting ripped off.
Nah, don't worry about it.
Cause somebody here shot up my cousin house.
Them motherfuckers be popping up, don't they?
On County.
All right, and who is your cousin?
Alexis Bryant.
All right. Why did you tell them to come get you if you had your own vehicle?
Because my girlfriend was in mine.
Your girlfriend was in yours?
Yes.
All right.
No, I'm wrong. Because I was going to get in the car with my girlfriend. I was getting dropped off to her.
Okay. And so, did you have guns?
Yes.
How many guns total were in the car?
I know I had 2.
And did you see any more?
Demetrius had 1.
Were you wearing dreads during that time?
No.
Okay. So, where did they pick you up from?
Cleveland Avenue.
Where on Cleveland?
The store, I think.
Which store?
BP.
Was that the same one you were at with that gun?
Yes.
Where you got arrested in May?
Yes.
Okay. So, do you just normally hang out at the BP with guns?
Yes.
So when they came and got you, what did they do?
Yes.
Hey, I'm trying to figure out who we're talking about.
Your Honor, I, first of all, asked him about people, and then I referred to those people specifically.
All right.
Who are those people?
Your Honor, I'd ask Phil not to continue the question. He'll have no problem.
So is it a vagueness objection?
Yes, it's a vagueness.
Yeah, I was specific. I asked him about a specific set of people.
I don't know
and
what.
specifically referred to them.
Yeah, why would
Maybe.
we want to know
I'm
what we're talking about?
Do you want to re-clarify, please?
I can continue and then I can ask a separate set of questions. Of course, Mr. Sharp has him on cross.
Well, I think we should be clear about what we're talking about right now.
Ask.
Thank you. Go ahead and clarify.
When I asked you about Garlington, Moncton, and Shannon,
You said Garlington and Moncton.
you didn't hear me say Shannon?
No.
Yes.
That
Let's take a
they was
break.
to
Hang on,
include-
hang on. Let's just take our mid-afternoon break right now. All right.
My son in here playing with his toys, man. My bad. Y'all hear them sirens. Ain't nothing going on around here.
Mr. Sharp.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross.
And you
I
objected.
objected, and I wouldn't have even thought about anyone doing this other than the fact that I've seen the prior behavior throughout this trial of this type of nonsense, where we try to trick a witness into think we're saying they, meaning 3 people, and then try to convince the jury that we're somehow including my client Shannon when it's clear that the witness is not following. That's what we're talking about, and it's disgusting. And I don't know how we cure it, but I'm going to move for a mistrial. I think it was completely intentional. Obviously, it was calculated. Obviously, when I asked for clarification, I would think anyone seeking the truth would gladly clarify. I'm seeking the truth. I would gladly clarify. No, it's sheepish grin and then.
All right, I understand your objection, and I understand what you were saying past that objection. Miss Love, I think
May I
one thing that,
respond?
no, you need to listen. I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond, and I make a ruling, even if that ruling is, please clarify, that you then need to obey what my order is instead of continuing to argue.
Your Honor, when I ask for clarification and consideration, I believe that as an advocate and as a person who is actually representing the victims who have been victimized in this case and who is representing as much as actually more than an officer of this court, and I represent something, I believe that the state has as much right to express, to request, and to ask for consideration and for an allowance to ask the questions that it wishes to ask as the defense does. I believe, Your Honor, the objection that was made, and I understand what Mr. Sharp said, but there are a couple of things at play here. One, Mr. Sharp is well aware that Mr. Zachary has said that his client was with him. He has said it in the interview that I'm holding in my hand. He is not being honest with the court when he is claiming that Mr. Zachary had no idea what I was talking about. I literally said Shannon, Demikian, and Motu, and I asked him how close he was with each of them.
Right, and then we went from that to his girlfriend, and then it was not unreasonable. And the objection could just be, vague, but it was not unreasonable to object to make sure that it was clear what the question was, who the they was in the question. And when I say clarify, that needs to be the end of it. And you need to ask a different question, rephrase the question, and let's move on. And there shouldn't be an issue with it.
Yes, Your Honor, if the state is not allowed to ask for clarification or consideration, that I understand.
don't know what you mean by that.
Your Honor, when I
A
asked,
clarification of my ruling, is that what you mean?
when I asked for permission beyond what the court has instructed, I did not know that I should not do that, so I won't do that anymore.
That's not what was going on. You're basically, it seems to say, I'm asking permission to do something other than what the court has just ordered me to do. And so if that's what it is, then no, you cannot do that. If you need clarification of a ruling, then of course you can ask that. And if you want reconsideration, then you can ask for that, but that does not need to go on in front of the jury. When I make a ruling, obey the ruling. And
all right, so listen up. State Farm was trying to charge me $197 for car insurance. No.
Okay.
Your Honor, I really haven't heard any explanation for what happened. I think it was calculated. I'm moving for a mission.
I'm telling you, see how crazy the DA is. Tomorrow I can't ask questions. Try to get Snake Jazzy. She crazy, man.
Trial. In the alternative, Your Honor, I do believe that there needs to be a curative instruction, or at least it needs to be clarified who they was. It doesn't matter what he said in the past. He lied in the past. I've already said that. I know what he said in the past,
right.
but what he's
We don't know, you don't know that he lied. You don't know what the truth is and what the lie is if they are inconsistent. And there may even be a reason for that. Although if they're virtually diametrically opposed, there probably is not an explanation. But when you say he lied, we don't know that.
Okay.
Just like Miss Love doesn't know when he lied.
Well, I'll put it like this. Mr. Stillwell was never charged with those crimes. And Miss Love was not asking about what he said in 2015. She was asking about today.
I understand.
And today, he was clearly responding, they meaning Mr. Garlington, and well, it's clear to me. I don't believe it's clear to the jury. And I believe it needs to be clarified immediately because, of course, I will have an opportunity to cross, but I will probably not have an opportunity to cross for about 4 days. And I don't think we should be misleading the jury on direct.
All right, I'm going to look back at what the transcript says. I mean,
like, cause she be up there filibustering, like for real, like come on, get to the chase, cut to the meat and potatoes. She be, oh Lord, she just said, what's taking too long to get the ingredients together? Dude, what color shirt did he got on? What color shoes? What type of temperature was outside? Was it raining? Was it sunny? What was the mood like that day? When you woke up, did you eat breakfast? Or was you just hungry to go rob somebody? Like that's the type of dumb question she be asking. I don't want to call the lady dumb, but I call it conniving. Let's call it conniving, which what they were trying to do to Young Thug down there in Georgia, Fulton County. Oof, Fulton County Blues, y'all.
and Ms. Love, you may, given that there's now a motion for mistrial on the floor, in assertion that you did things purposefully, you may respond to that.
I vehemently object to the mistrial. I vehemently object to any mistrial, and I beg the court to look at the transcript and see what I said right before I asked him the people that I just mentioned. And I would ask that the court, I mean, if the court deems it appropriate that such language is gross and all of the disparaging remarks made by counsel for the defendants are appropriate, that's one thing. But I'd ask that the court limit that type of behavior, which is, not becoming of officers of the court.
I agree with that. It is not becoming.
Oh yeah, man, we gotta tap in right there, man. We'll be back with some more love bloopers of the 2024 bring in the new year, bro. Look at that corruption right there. That is crazy, man. I gotta handle some business, but I will be back. Give me a couple minutes. Y'all roll up, get your popcorns ready. We're gonna go up saying You Feel Me podcast. Make sure you like, comment, and subscribe and share. You feel me? And we out of there.